Welcome to the McNees Energy and Environmental Law podcast series. This podcast will address the Supreme Court ruling on electricity demand response by Robert Weishaar, attorney at law. Mr. Weishaar is the chair of the Energy and Environmental Group at McNees.
Thank you for joining our podcast. I will be discussing the recent Supreme Court opinion on electricity demand response. On Monday, January 25th, the United States Supreme Court issued an opinion that has significant implications for electricity consumers, electricity suppliers, and state and federal regulators. The Supreme Court's opinion upholds a Federal Energy Regulatory Commission order that provides compensation to customers that commit to interrupt their energy consumption when directed to do so by wholesale system operators. Such interruptions typically occur during system peak periods when electricity prices are high, and for these interruptions, customers are paid the wholesale market clearing price. The FERC order includes safeguards to ensure that payments for such demand response provide a net benefit to all consumers. The order envisions that increased demand response will promote competition in wholesale electricity markets and help keep wholesale market prices just and reasonable as required by federal law. In the 6-2 opinion, written by Justice Kagan, the Supreme Court reversed a decision by the United States Court of Appeals for the D.C. Circuit. The Supreme Court found that FERC had jurisdiction under federal law to issue its order. The Supreme Court also found that the order was regulating a quote-unquote practice, here demand response, that directly affects wholesale energy markets. Because of this direct effect, FERC, not the states, has authority over demand response in wholesale electricity markets. The fact that state jurisdictional retail rates may be impacted is, according to the court, of no legal consequence when determining FERC's jurisdiction. The Supreme Court also affirmed FERC's decision to use the market clearing price as an appropriate payment for demand response. The Supreme Court's opinion has both immediate direct implications and potential longer-term implications for electricity markets and electricity market participants, including consumers. The likely near-term implications of the opinion include demand response participation in wholesale energy and capacity markets, which was chilled during the lengthy appellate process, is likely to increase. And an increase in demand response will increase competition in wholesale electricity markets and further enhance the flexibility of the interactive grid as concepts such as the Internet of Things become more entrenched in our day-to-day practices. Demand response contracts will be on firmer footing, and the heightened importance that was being attached to regulatory out clauses in those contracts is likely to diminish. In the coming months and years, FERC, market participants, and state commissioners will inevitably attempt to stretch interpretations of the Supreme Court's opinion. The key issue going forward will be which practices are reasonably considered to have a direct effect on wholesale rates and which are not. The Supreme Court stopped short of establishing any practical rule or bright line for applying this standard. Consequently, potential longer-term implications of the Court's opinion include FERC asserting broader authority over other practices that it considers to be directly affecting wholesale electricity prices, including ownership and operation of distributed generation such as rooftop solar and microgrids, implementation of state-initiated renewable portfolio standards, and other issues that have historically been considered more retail in nature. Electricity market participants will need to pay close attention to these emerging developments. For further information about this extremely important Supreme Court decision, please contact us using the information on the screen. Thank you.